Very good morning. The next, all the CA Foundation students, the next lecture, that is part 2 of law answer writing. Okay. So you focus on the material. I have already shared the material in WhatsApp group of BRICS Academy. If in case any outsider is watching, please do call on our number. We will share it, right? So this is for your benefit. So it's already there on ICA website. If in case you don't find, you please let us know. We will share it, right? The next one, next is third question. If you see, third question, if you see, Sarthak is employed as a cashier on a monthly salary of 50,000 by ABC Bank for a period of 3 years. The Mohit gave surety for Sarthak's good conduct. So Mohit became a guarantor. I mean, good character in the sense, if in case he takes money or anything is there, he gave a surety. So the moment you hear this word, definitely it is Indian Contract Act only, but it is related to guarantee contract. After 9 months, the financial position of the bank deteriorates, means financial position of the bank is affected very badly. Okay, that is one thing. Yeah, financial position is affected very badly. Then Sarthak agrees to accept a lower salary. So actually, the salary is how much? 50,000. But Sarthak agrees to accept because bank situation is not very good. So he agreed for 40,000 per month. 2 months later, it was found that Sarthak had misappropriated cash. Misappropriate means he took some cash. He took some cash from the bank from the time of his appointment. So what is the liability of Mohit? So Mohit, who is Mohit actually? Mohit is the person who gave a guarantee. So it's a guarantee contract. It's a guarantee contract, okay? So he's asking what exactly is the liability of Mohit. So why? So generally first important question comes, as I said, whenever question is given like this, first understand which concept is it related to. So guarantee contract, finished. Next question is who gave a guarantee? Mohit gave a guarantee for the good conduct of so and so. But there is something actually. There are changes in terms and conditions. Initially, the salary was 50,000. Later on, the salary has been decreased to 40,000. And this change in terms and conditions regarding salary has not been communicated to surety. That is Mohit. You got my point. Now, later on, 2 months later, what happened is it was found that Sarthak had misappropriated. He took some cash. Now, whether Mohit is liable for that cash which was taken by Sarthak or not, that is the point. So over here, guarantee contract is one thing, and there is a change of terms and conditions regarding the salary, and the creditor and debtor had some change, had some adjustment related to salary, but that has not been communicated to the surety. That is the concept. Okay, let's see the answer. So answer my first thing is, if you remember the section, it's better to write the section. If in case you don't remember the section, you start the sentence like this, as per the relevant sections of Indian Contract Act. If in case you remember the section, I always advise in law, start with the section. If in case you don't remember, as per the relevant section of Indian Contract Act 1872. Don't simply say Indian Contract Act. Instead, you keep writing Indian Contract Act 1872. That is the first line you have to write. If in case you remember the section, start with the section. Better if you prepare like this, if you revise some sections, you will be able to remember, better to remember. Okay, so I'm starting in the first paragraph. I'm trying to explain what is the concept, where there is any variance in the terms. See, the keyword is variance. So the moment you read the question only, you should understand the problem in first 3-4 lines only. You see, when I was reading that question only, I told you there was a decrease in salary. Original salary was 50,000. There was a decrease in salary. That means there was an understanding between creditor and debtor regarding the change of terms and conditions. And these change of terms and conditions are supposed to be communicated to whom? The surety, but it was not communicated. So it's a where there is any terms and conditions between debtor and creditor, etc. It would, without surety consent, it would discharge the surety. So if you had changed terms and conditions without informing surety, surety is automatically discharged and is not responsible for anything. Thereafter, after change of terms and conditions, thereafter, if that debtor does anything, surety is not liable. Indirectly, in the first concept, what we're trying to declare that if in case there is a change in terms and conditions between debtor and creditor, and that has not been communicated to surety, surety will be discharged from his liability. That is the point. All right. Next one, in the given case, so what I said very clearly, second paragraph, you always explain what actually happened. In the case, in the instant case, creditor has made a variance. Salary has been decreased without the consent of surety. So surety is dischargeable. Okay, you explain exactly what happened. I'm not saying this much is sufficient. I'm saying I'm straight giving you answers. I'm straight telling you what you are supposed to write in the second paragraph. Next, therefore, taking all above things into consideration, Mr. Mohit is liable as a surety for the loss suffered due to misappropriation cash by Sardak during the first 9 months only, but not for misappropriation after. That means until the date of original salary, if in case anything happened, definitely Mohit will be responsible. But after change of salary, after 2 months, this misappropriation happens. So definitely Mohit is not responsible. So you can say very clearly after change of terms and conditions without the consent of surety, surety is not aware, surety is not communicated. So for the Sardak behavior of misappropriation of money, Mohit is not responsible because that incident happened after the change of terms and conditions which are not communicated to surety. Got it. If in case you have any problem, just go back and rehear once again. That's it. That is, it's a recorded lecture, so you can just rehear once again. Okay, that is one thing. So clear. That question is clear. That is how you have to answer it. You listen to all these questions. By the time I finish discussing what happens, you will get to know exactly the order of the question. That is the advantage of listening now. Last minute listening will definitely help you. You will get an idea as to exactly, because when you read 10-15 questions like this, then you will come to a conclusion, oh, this is how we need to write the answer. So you will write. So don't come to a conclusion, oh, I'm able to understand, so let me skip this video, etc. So you first focus, right? No matter what, you use headphones properly and listen to this lecture carefully, right? Next question, fourth question I'm reading. Rahul was a disc jockey at a five-star hotel. As per the contract, he's supposed to perform every weekend. All right, twice a week. Rahul will be paid 2,500 rupees per day. However, after a month, Rahul willfully absents himself from the performance. Means he agreed to perform twice a week, but he deliberately did not attend to perform. Taking into account the provisions of Indian contract, it answers the following questions. So, what is the question actually? Mr. Rahul agreed to perform, but he failed to perform deliberately. Does the hotel have right to end the contract? First thing is, ending the contract is nothing but in law we call it as rescinding the contract, means cancellation of the contract. The second question says, if the hotel sends out a mail to Rahul that they are interested in continue the contract and Rahul accepts, can the hotel rescind that? That means if hotel said we are still interested in you coming and performing the contract, understood, and Rahul accepted it, can the hotel rescind the contract after a month subsequently? That means once you have agreed to affirm, once you have agreed to continue the contract, can you cancel the contract? Okay, that is it. So third question is, in which of the case termination of contract or continuation can the hotel claim damage? So I mean whether, so there are two scenarios. If in case hotel people have decided to continue, or hotel people have decided to cancel the contract, in which case you can claim damages. Common sense would apply. If you have decided to cancel the contract, you're no longer interested, then definitely if you have suffered a loss, you can definitely claim the damages. But the confusion starts only when hotel people have decided to continue the contract, but still can they ask for damages? Okay, let's see now. So answer is this is also contract act only, right? Performance of contract. We must have heard the 9th or 8th lesson, performance of contract. In that lesson, you will find this concept. So section 39 says, it is understood when a party refused to perform or disable himself to perform, the following two remedies will be affected. So that means when the promiser has agreed to perform the contract and he did not perform the contract, the affected party has the following two remedies. Number one, he may terminate the contract. He may terminate the contract. Number two, he may indicate by his words. He may indicate either by his words or by his conduct that he would like to continue. So option number one, affected party can cancel the contract. Option number two, he may indicate by his words or conduct that he would like to continue the contract. In either of the cases, promisee would be liable to pay damages. Understood now? That means even if promisee continues the contract also, if he could show that he suffered a loss, definitely he is eligible for damages, right? In the given case. So now this kind of question, why this kind of question is special? Because there is a case law plus 3 questions. Each first explain the concept, then explain what happened in the case, then explain each question. So answers to these questions should be at the end. Don't immediately start. Some of you will start the answer like yes, so and so he has a right to claim, etc. Don't do that. First explain the concept aram se, because slowly first you have to explain the concept, then you explain what happened in the case, what is actually the dispute lying there, then last paragraph you have to start slowly explaining question wise. So what is the first question? First question, if you see, does the hotel have any right to end the contract? Yes, obviously. Obviously, when you did not perform the contract, what you have agreed to perform, then I have no other option. I can cancel the contract, right? I can cancel the contract. So simply I say, yes, hotel has the right to cancel the contract. Second one, you see, the hotel has the right to continue the contract with Rahul if they want to, yes. So that means indirectly, second point tells us what? The affected party has two options, Polki, in the concept we already explained. Number one, affected party, if he wants, he can cancel the contract. And second one, he can indicate that he would like to continue the contract. Both. So once the right is exercised, it can. But only problem is if you have already decided to continue the contract, how can you cancel the contract? You cannot cancel the contract subsequently, right? Then in both the cases, whether you cancel the contract, you continue the contract, no matter what, affected party has every right to claim damages. Affected party has every right to claim damages. Quickly, grasp quickly. If in case you are finding any difficulty, just go back and rehear once again. Finish. It's a recorded one. All right. Yes. That is how you need to answer such kind of questions. So always when there are 3, 4 multiple questions in one case law, answer those questions at last, not in the beginning. Remember carefully, okay? Question number 5, let's see. Examine whether following constitute a bailment or not. Bailment is also a contract act concept. What is a bailment? When one person has voluntarily transferred the possession of goods to another person, it is called bailment. Why do we do bailment of goods? Because for a specific purpose, like if clothes are given to tailor for stitching, it is bailment. If the car is given for a servicing, it is bailment. Understood? So bailment happens when one person has voluntarily transferred goods to another person for a specific purpose or a specific custody. Once the purpose is over, that person to whom the goods are given is called bailee. The person who's giving goods is called bailer. So the bailee, once the purpose for which goods are given is accomplished, he's supposed to return the goods as it is, right? Understood? That is bailment concept. So what is he asking? Explain whether following constitute bailment or not. So he's trying to ask you, better tell me whether these are bailment or not. So once again, I'm repeating, according to bailment definition, bailment is voluntary transfer of possession of goods from one person to another person. That means there should be a transfer of possession voluntarily. There should be a handing over the goods. I mean, one person should be handing over the goods to another person for a specific purpose or something. So look at the first question. Vikas parks his car at a parking lot. He parked the car and he locks it and keeps the keys with himself. That means he did not hand over the goods. So bailment happens when one person has voluntarily transferred the possession of goods. But he came and he parked the vehicle, he locked it and he kept the keys with himself. He did not hand over the vehicle. Next, seizure of the goods. Seizure of the goods in the sense you took over the goods, like income tax authorities have taken over the goods. They have taken over the goods. So first of all, what you are supposed to do, it's a bailment. So explain what is bailment. So 148 says bailment is a delivery of goods by one person to another person for some purpose. Example, I told you when the car is given for a servicing, it is called bailment. When the goods are given for a repair, it is called bailment. Once the purpose for which goods have been given is accomplished, then goods are supposed to be returned or goods are supposed to be. So whatever purpose for which goods are given under bailment, bailee has to return the goods or he has to follow the directions given by whom? Bailer. That is a concept. If you remember, this bailment, only one very important section, that is 148. Please remember the definition, right? So for bailment to exist, bailer must give a possession. That's what I told you. Once you know the definition, then you can understand. Bailment happens only when one person has deliberately, voluntarily transferred the possession of the goods. Then only bailment happens. Then only bailment happens. Is my point clear? So now next question is, what is the first question Vikas Parks is it a bailment? He is asking you to decide whether it is a bailment or not. So he parked the vehicle, he did not hand over the goods, means possession is not given. So remember, maybe the duty of the parking person can be a bailee, no doubt about it, because he has to take care of the parking. He might not be taking care of a particular car, but in general, he has to take care of the parking. So it's not a bailment, first one. Second one, the possession of the goods is transferred to custom authority. Therefore, bailment exists in 148. So here, seizing of the goods by custom authorities. That means when custom authorities have asked here, this context is saying, but actually speaking, when you confiscate the goods, it's not a bailment. When you confiscate the goods, it's not a bailment, voluntary transfer. But seizing in the sense, unless he gives, he won't take. No, so in that context, this ICA has taken the answer. It says possession of the goods is transferred, therefore bailment exists. The section 148 is applicable. So 148 may what it says for some purpose it is given. Generally, if tax authorities have confiscated the goods, there is no bailment. He has to give it. He has to voluntarily give it. Understood? That is the meaning. So this kind of questions also, first you explain the concept, next you have to explain answers. One more contract act question you see. Mr. Sanjay Kothari was a big businessman having 2 sons and 1 married daughter. He decided to gift his house to his daughter. So there is a gift contract. So mostly this is related to gifts related, you must have studied in consideration. The situations where consideration is not required but contract is valid, okay, you have one concept in consideration. For this purpose, he called his lawyer at his house and made a written document to such gift. The lawyer advised him to get the transfer instrument registered. Understood? So this, now only you understand. So when you are reading the questions, by the time I finish 10 questions, you must be able to understand how to trace the concept first in the question, how to trace the concept in the question first. So if you see here, first of all, there is a natural love and affection between father and children. Second thing is there is a gift. Third one is if you want natural love and affection contracts to be valid, we studied in consideration lesson, 2 conditions must be satisfied. Number 1, it should be in writing. Number 2, it should be registered. Number 3, it should be between near related people, so family members. It should be in writing and it should be registered. So it's a natural love and affection. So third point clearly tells us it is written, registered and written. When they both were going for registration document, they met with an accident and both died. He called his lawyer, etc. Okay, right? Next, the later daughter found the document and claimed the house on the basis of document. Later on, daughter found the document which was signed by her father. Then she claimed the house. Explain whether she can get the house or not. So this is like natural love and affection contracts, gift already completed. If you see, one of the exception where contracts are valid, even though there is no consideration, is gifts completed. You go back to consideration lesson and see the exceptions under which contracts are valid even without consideration. One very important point you will find in that concept, gifts completed are valid without consideration. Later on, anything happens, it will not be affected. Once gift is completed, no matter what happens, once gift is completed and signed, registered, no matter what happens, it will not be once gift is completed, no matter what happens, even before registration, nothing will happen. See the concept. So section 25, briefly I gave an answer. Section 25 talks about what? Any agreement which is made without consideration is void, but there are certain situations where agreements are valid even without consideration. In general rule is what? An agreement without consideration is void. Okay, but however, there are some exceptions where agreements are valid even without consideration. What are those agreements? One agreement is like agreements made out of natural love and affection. They have to be in writing and registered. Finish. That is the first paragraph. Second paragraph, in the instant case, the transfer house on account of natural event affection standing near relation, but it's not registered. Hence, the transfer is not enforceable. So my biggest confusion here, I mean, students can get confused with 2 points. In that consideration lesson, we studied once gift complete is valid no matter what, no matter what happens later. Once the gift is completed, gift is valid no matter what happens later without consideration. But this question is related to natural love and affection. Natural love and affection mean 2 conditions must be satisfied. Third line, you see, the lawyer advised him to get the transfer document registered, means it's not yet registered. While on the way for registration, they met with an accident and they died. That means it is in writing, but it is not registered. That is a keyword. Okay, so last paragraph, it says it's not enforceable. Why it is not enforceable? Because it is in writing, but it is not registered. So any natural love and affection without consideration, if you want to make them valid, 3 conditions must be satisfied. It should be in writing, it should be registered, and it should be between near related people. Father and daughter, 1 condition is satisfied. It is in writing, 2nd condition is satisfied. But the 3rd condition is not satisfied, that is registered. So you should be very careful about these answers. Because sometimes what happens, no, if you go by gift contract, once gift is complete, it's valid. It's valid no matter what happens later. But here, it is natural love and affection. Natural love and affection contracts must satisfy 3 conditions, no? Understood? That is the point. All right? Yes? Clear? One more question is one more small question. You see, Mr. Ayush employer induced his employee Bobby, Mr. Bobby, to sell his 1-room flat to him at less than the market value to secure promotion. For the sake of promotion, at less value, he wanted to sell. Next, Mr. Bobby sold the flat to Mr. Ayush. So understand carefully. Mr. Bobby sold the flat to Mr. Ayush. Later on, Mr. Bobby changed his mind and decided to file a suit on Mr. Ayush. He wanted to cancel the contract. Examine the validity of contract as per the provisions. So what is the concept involved? First of all, employer-employee. So employer-employee come under what relation? Will they come under undue influence? Will they come under undue influence? 101% employer-employee will come under undue influence, no doubt about it. Okay, so you have to explain very clearly what is the meaning of undue influence. So first paragraph, it says undue influence means when there's a existing relation between people and one person is dominant person, another person is weak person. Dominant person might be taking unfair advantage over the weak person. What do you mean by taking unfair advantage? Dominant person taking unfair advantage over the weak person is nothing but taking less consideration. So in the question very clearly it is there, no? So first you trace what exactly is the concept connected. So we understand employer-employee relation. So therefore there is an undue influence relation. Master, servant, father, son, Guruji, disciple, understood, doctor, patient. These are all relations where there can be a presumption of undue influence. There can be a presumption of undue influence, right? So first concept, you explain what is undue influence. Second concept, means what? It says when the consent is caused by undue influence, the contract is voidable. Obviously, when the consent is taken by undue influence, 100% we treat that contract as voidable. What is voidable? Where one party is affected. If in case that party wanted to go to court, he can go to court and enforce it. Voidable contract means what? One party is affected and he only can go to court to enforce it. So second paragraph clear. So I'm giving you summary answers. So you have to add something and write properly, right? Therefore, contract between Ayush and Bobby, since they are employer and employee relation, then definitely there is an existing relationship. That existing relationship will give us a clarity that there is an undue influence. So later on, if that too less value means unfair advantage, right? In the question it is given less value, no? So unfair advantage. So Mr. Bobby can file a suit and cancel the contract. Only thing is an undue influence, you can't claim damages, but you can definitely cancel the contract. You can definitely cancel the contract. Point clear? Yes. Next. One more question. You see, one more question related to, you understand now. Slowly, you should get used to this contract. Case law questions answer rating. Okay. Next one. Mr. Suraj promises Mr. Manoj to paint a family picture for 20,000 and assures to complete his assignment by 15th March 2023. Unfortunately, Mr. Suraj died in an accident on 1st March 2023. 15th March, but 1st March, unexpected event happened. This is what is called unexpected. When an unexpected event happens, contract becomes void. Okay, next, can Mr. Manoj bind the legal representative of so and so? So generally, what happens when the contract is entered, and if a person dies, his legal representative has to perform, no doubt about it. But the contract nature, you see carefully, it's a what? Paint a family picture. Oh, this is a personal contract. So when this is so that is what you have to be very careful, slow, read slow and understand what is there. So generally what normal student will understand, oh, so promiser died, legal representative has to perform. Legal representative has to be a painter, no, first of all. So singing, dancing, teaching, painting, these are all what kind of contracts? Personal contract. Personal contracts are supposed to be performed only by promiser. If in case promiser dies, contract becomes void. You cannot force legal representative to perform the contract. That is the concept. Then Suraj for the promise made by so. Suppose Mr. Suraj had promised to deliver some photographs to Mr. Manoj against the payment of 10,000, but he dies before that day. Will his representative be bound to deliver photographs, etc.? He's asking. So overall, is legal representative responsible? So here in this question, under what circumstances legal representative is responsible? Under what circumstances legal representative is responsible? If in case legal representative responsible for any circumstance, to what extent he is responsible? I am telling you, when there is a promise of doing certain personal things like teaching, dancing, acting, painting, etc., these personal contracts will not fall on legal representatives. See there. First question, it's a parties must perform or offer to perform, etc. Next, promises bind the representatives, no doubt if the promiser died. But as per section 40, it appears that the nature of the contract, intention of the parties is very important. Understood? That means depending on the nature of the contract means what I said here, the personal contract here. Personal contract, legal representative should be competent to perform it, no? Like singing, dancing, acting, painting, how can you say legal representative can simply perform the contract? It's not possible, right? So as per section 40, in case where Mr. Suraj has to paint a family picture, Manoj cannot ask legal representative. The reason being it's a personal contract. That is the point. Keyword is that. In terms of provision section 37 above, in case Mr. Suraj had promised to deliver some photographs to Manoj, the legal representative shall be bound because it's not a personal contract. Some photographs. Just some photographs. Already they have taken photographs. It's like taking photographs. Yes. So moral of the story, this point clearly tells us that whenever anybody has made a promise, as long as it is not personal in nature, four people can perform. If the contract is not personal in nature, he himself can perform, his agent can perform. If he dies, his legal representative can perform. If he becomes insolvent, his officially assignee can perform. Even performance of the contract, as long as it does not involve personal skill, even a third party, stranger also can perform. I repeat, stranger also can perform. A stranger in the contract cannot file a suit, but stranger can perform the contract as long as the contract nature is not personal in nature. So read the question carefully. So he's asking legal representative to paint a picture. Painting, dancing, teaching, acting, singing, these are all what? Personal contracts. So personal contracts will not fall on legal representative. Other contracts also, they will fall on legal representative, but legal representative will be responsible only to the extent of the assets that he has received. That means legal representative in general contracts will not be able to perform the contract more than what he or she has received from the deceased party. Got it? Yes. Okay. One more question is in contract act. What is quasi contract? So this kind of like quasi contracts, you must have heard about quasi contracts, the contracts where rights and obligations are created by law. You must have heard about contingency contracts, the contracts which are based on happening, non-happening of an uncertain event. You must have heard about wagering contracts. Remember this. Quasi contracts, wagering contracts, contingency contracts. There is every possibility. Their rules, examples, they might ask you theory questions. I repeat, quasi contracts, contingency contracts, wagering agreements, there is every possibility they might ask you direct theory questions. So be very careful. So, quasi contracts are those contracts where in general, so you have to start answering in general, like section 67 to 72. Section 67 to 72, better to mention, but theory questions like this, we don't write section, nothing happens. But case law questions, they generally expect sections. There also, if you don't remember the section, you start the line like as per the relevant provision of so and so. But theory questions like this, if you remember sections, you write like section 67 to 72 deals with quasi contracts. So in general, rights obligations are created by parties, but there are some situations where rights obligations are created by whom? Law. So when the law imposes obligations on the parties, that is quasi contracts. They are not real contracts, but valid contracts. They are based on a principle of a prevention of unjust enrichment. Right? This is what, right? That means you are not supposed to make somebody rich at the cost of others. This is what introduction. After introduction, there are some points. 5 points are there. So what is he asking? Characteristics is asking. He's not asking examples. Examples, if they ask, then definitely you will start writing examples like finder of the lost goods, money paid by mistake, etc. So if you look at the quasi contracts, contingency contract, wagering agreements, theory concepts, whatever is there, you just go through. There is no agreement. Next, it is not on the basis of contract. Understood rights are related to money, money related only. Okay, next one, the right is available against a specific person, not the entire world. So these are all general features. You just go through that. But if they ask you examples also, then you have to write finder of the lost goods, money given by mistake, money paid with to an interested person, non payment for non-gracious activities. Okay, some 5 examples are there. Section 67 to almost 68 to 72. You have got some points related to quasi contracts. Go through this quasi contracts, wagering contracts, and contingency contracts. There is every possibility one question they can ask you. So that too theory question you can expect. So make sure you go through it. All right. So I hope you understood now. Your answer writing skill should be to the point. Do not simply take the answer somewhere and bring something else which is unconnected to the answer. Straight answer, because for 3 marks, 4 marks, maximum 10 to 15 lines, you can finish the answer. It is the concept that is more important, not the number of lines. But crystal clear, even if your English grammar is not good, whatever it is, you first present what you have understood. Don't try to present answers like a mug up answers, please. All right. Yes. Chalo. One more class I will record. Like in that, I will explain sale of goods and other questions, how to answer. Have a good day. Take care.